Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. Tonight we're going to be talking about the Judicial Standards Commission here in Montana and kind of the framework a little bit in other states as well. But before we start, would you please hit the like and subscribe button, especially if you're on YouTube. We're at about 930 followers. Our target, of course, is 1,000. When we reach that point, we'll actually be able to better distribute our material over YouTube, which would be fantastic, especially since the more viewers, the more reactions, the more input I get, the more information I have to actually work with. But if you give us a like and subscribe, also take the time to share this with your friends, your family, post it on social media, Facebook, Instagram, wherever you feel that would reach the most audience. Now, keep in mind, also, if you're watching on another platform, of course, you have the ability to like, subscribe, and share from those mediums usually as well. But by all means, use the parameters within the specifications you have. But if you really want to show your strength and support behind these programs, do visit us on YouTube, because that's where we're centralizing our attempts to reach the most media. Now, that being said, also, there's going to be a reference to text in here. I am going to be providing a link, as I often do. If you're watching this video and the link is not attached, if you do not see any text attached to this video, by all means feel free to visit us on our original format, which is monspiracy.podbean.com, which is where you can actually get the original and you'll guarantee to have the text attached to it. Okay, that being said, let's start tonight's program. I've got a lot to talk about. Now, for anyone who doesn't understand, the Judicial Standards Commission is, or equivalency, they're called different things across the country. Montana Standards Authority, Montana Oversight, whichever agency you want to call it. In Montana, it's called the Montana Judicial Standards Commission, often abbreviated to JSC. Now, what this purpose of this program is to actually look into complaints of misconduct by judges, to oversee and supervise them in their roles, to make sure they're actually adhering to what are called the Montana Judicial Ethics, or actually the canon of judicial ethics, which are basically a set of rules that set the ethical guidelines of judicial officers within the state of Montana. Very similar to the Commission on Practices, which is for Montana attorneys, which is set up by the Montana Standards it sets their own rules for their attorneys. The Montana Canons of Judicial Ethics sets the boundaries for judges. Now, in Montana, the model is we have 5 members. The Constitution requires the legislature to set up the entire commission, i.e. the commission itself and the large framework of how things are appointed are set up by statute. The Constitution requires, Montana State Constitution requires legislature to set it up, but doesn't offer a whole lot of structure or guidelines in how to do so. It does identify, though, that there are supposed to be 2 district court judges, which are elected by district court judges across the state and then certified by the Supreme Court Chief Justice, who is, of course, Mike McGrath. Anyone watching my videos from the past will understand my opinion of him, and I still have to take the time to actually break down and actually do a specific episode dedicated to him. And maybe I'll do that next. It's just there's so much out there, so much to talk about, so many subjects that oftentimes the individuals who are involved in the Great Montana Conspiracy fall by the wayside out of necessity to talk about the overreaching and broader issues. But in this particular case, the 2 district court justices must be certified by Mike McGrath, which means the Supreme Court gets to decide whether to certify them or not. If he doesn't like them, he doesn't have to certify them. There's nothing in the law that says he must certify them. It just says they must be certified by him, which means if the district court judges pass and amongst themselves come up with 2 nominees, and Mike McGrath doesn't like them, he doesn't have to certify them. And he can sit there and hold off and force the district court judges to go back and re-decide and choose somebody else. So again, Supreme Court actually gets the ultimate authority here. Then the 3rd person on this panel is a lawyer appointed by the Supreme Court. Again, Supreme Court gets to make this decision, so it basically controls who 3 of the people are on this commission. And then we have 2 citizens who cannot be lawyers and cannot be judges. There's nothing that says they cannot be former attorneys or former judges, just they cannot be attorneys or judges. And these are appointed by the governor. Now, all of these positions are confirmed by the state Senate. So the Senate gets to approve them, just like in our federal Constitution. when a judicial officer gets sworn in, the commission on the Senate gets to appoint judges. Well, the Senate in the state of Montana gets to basically sign off on any people that are brought forth to serve on this commission. Now, I've never seen anything to suggest that the Senate actually ever rejects anybody. I mean, really, it's just, okay, we'll sign off on it. I've never seen an issue personally where the state Senate has come back and said, well, we don't like this person, choose somebody else. Supreme Court, different story, but not the Senate. And I don't know whether that's because it's a citizen legislature, whether it's just a process, they just go along with it and they don't fight it, they don't buck it. Oh, the Montana legislature in recent years has actually been, especially the House, has actually been very aggressive against the state Supreme Court. So maybe we might see some of that changing in the near future. But as it stands right now, I have not seen anything. As I researched this article, I looked specifically for examples of this. I could not find any. So keep that in mind as we move forward. Remember, in Montana, judges must be attorneys. So essentially what we have are 3 attorneys, 2 of which have attained the level of judges, overseeing other judges, and 2 people who are not judges or attorneys, which means, by criteria and definition, you have the judiciary comprising 3/5, 60% of the board overseeing themselves. And guess what? The district court judges get to co-chair it. It's not a revolving issue. It's not saying, okay, the 5-panel judge will decide amongst themselves who shall chair it. The district court judges get to chair it automatically. They co-chair it, which means the people who have no legal background have even less vote or influence if they can't even approach the chair. If the chair doesn't want to hear them, they don't have to. They basically dominate it. They just need 3 of the 5 to agree with the positions, and guess what? There's 3 lawyers on that board of commission. So what power do the 2 people have for the governor? They're outvoted every single time. Clearly the legal profession, which is biased toward protecting its own, as I've mentioned many, many times, they outnumber the non-legal representatives on the commission. So it's the same analogy, and I keep bringing it up, and I keep saying it. You can't ask the foxes to guard against foxes eating chickens, because the foxes aren't going to do anything to stop their fellow foxes. In fact, they're probably going to join in. They're going to take advantage of the circumstance and say, oh yeah, well, give me a breast, would you? Give me a couple legs. Yeah, great, thanks. Okay, we didn't see anything. Well, you asked us to watch for them. We're watching for them. We don't see anything. We don't see them doing anything wrong. Because foxes cannot be trusted to judge other foxes when it comes to eating chickens. You can't ask judges to be responsible for overseeing themselves. They don't want accountability. As I've mentioned with the Great Montana Conspiracy, the corruption is already present. It is prolific. It's part of the good old boy network where everybody just knows everybody else is corrupt and they don't care. It's an elite structure that exists over the citizens of Montana and oppresses them and abuses its power over them on a regular basis. And they don't want accountability. So why would a commission on judicial ethics, Judicial Standards Commission, actually want to oversee? And actually, according to statistics, which I'm going to reveal the source of here in a little bit, 98% of complaints brought against judges in the state of Montana every year are dismissed. I can speak from personal experience. I have filed 5 separate complaints through the years against justices, against Flathead County justices. I have never received a single response or even acknowledgement to my complaints from the Montana Judicial Standards Commission. I mean, this is ridiculous. And because of the way the laws work, the complainant is forbidden by law to even mention the existence of the complaint. So I can't legally tell you I filed a complaint against this judge, that judge, and the other judge, because I could actually be held in contempt and see jail time for telling you who I filed complaints against, because of the confidentiality laws. I could actually do jail time. It's a crime in Montana for me to tell you I filed a complaint against Joe Blow, who happens to be a justice sitting on whatever justice court. There is no Joe Blow in the state of Montana, just to be clear. But that being said, I am forbidden. Any complainant is forbidden. There's no way to publicly know which judges have had complaints brought against them, if any, how many, how often, frequently, anything, or even the misconduct that's alleged. And remember, this is very important. Most laymen, and that's not an insult, it's just people who do not understand law or are not part of the legal profession, do not understand when a judge is breaking the rules. They don't know. They don't have a legal background. Therefore, they don't recognize when to make complaints, nor, in most cases, do they even know who to make complaints to. It's not like the district court says, today we're going to call to order this case. By the way, before I start, anybody who has any issues against me, the Montana Judicial Standards Commission is the lawful authority that oversees me, and I encourage you to make any filings and complaints with them, and you can get the information in the pamphlets at the court clerk's desk. Of course, they're not going to say that. When you don't want oversight, you don't tell people how to do it. And remember, it's a stacked system, so you've got a pretty good chance that even if they did do that, a complaint wouldn't go anywhere, because there's nothing compelling the Judicial Standards Commission to actually do anything. Because guess what? The Judicial Standards Commission is actually part of the Montana Supreme Court. They're actually considered to be even though they're considered to be an integrated part of government, just like the Commission on Practice, as it is, and the State Bar, are all integrated underneath the Supreme Court. They get to decide all this stuff. They get to tell you, if they don't like someone on the commission, they control 3/5 of the board. They control 60% of it. They get to kick them off. They could say, okay, we don't like you, replace. Because they have the power. Who actually does anything to hold anyone accountable if the people who you hold accountable can fire you? Properly, Judicial Standards Commission should be overseen by non-judicial officers. It should. It should, as every other oversight issue I brought up on this podcast, citizen review is tantamount to a democratic elected system. The government must fear the people, not the other way around. They don't. They shouldn't. When the government fears the people, there's liberty. When people fear the government, it's tyranny. And again, and I used this example before, if you do not believe we live in a tyranny, let me ask you, if you do not believe you live in fear of the government, let me ask you this question. What is your first response, your gut instinct, when you see a cop pull up behind you or beside you on the road? Even if you're doing absolutely nothing wrong, you're following the law, you're driving along, when you see that cop, 99% of us feel fear as our first response. We check our gauges, we check our speed, make sure our headlights are on, we look around to make sure we're not violating any rules or laws, because we're afraid of what that guy behind us wants to do. We're afraid of getting that ticket. We're afraid of the repercussions of that officer pulling us over. Not because we're criminals, not because we're doing anything wrong, but because we live in fear of police. And that's saying nothing about if you happen to be black or Hispanic and dealing with racial prejudice to add on top of it, just normal white people. Anybody seeing my skin complexion recognizes that I actually have Native American Apache ancestry. So I actually have Native American. When I get really dark, really dark, I've actually been told I look Hispanic. Not that I'm saying there's anything wrong with that, but racial profiling is a very real thing. Okay? So, and as we progress through the summer, you'll probably see me get pretty dark because I spend a lot of time outside. I do a lot of fishing. So I'll be going outside, I'll be getting darker, and you'll be seeing my darker complexion come out. And like I said, people have actually said I look Hispanic. I personally don't agree with them. That comparison has been made. So yeah, I'm actually one of those people who could be potentially racially profiled. So what is it? It's all about how the government sees you. And if you're afraid of that police officer for whatever reason, you do not have liberty. You're living under tyranny. That's the way it works. There's no other argument at that point. That's the way it works. You either have the government fearing the people, or you have the people fearing the government. And most of us fear the government. We fear the IRS, we fear the police, we fear lawsuits, we fear whatever. We fear government oversight. We fear government coming down on us in whatever regards. We dread having to deal with government. Whether it be through an estate, or whether it be dealing through going down and even paying our water bill at the city department. We dread dealing with government. Let's face it, we do. Because we have an innate fear. You may not want to call it fear, but that's what it is. Another thing I often say is it looks like a duck, it quacks like a duck, it walks like a duck, it's probably a duck. Even if it's holding a sign that says it's a chicken. Okay? It's a duck. If you elicit a fear response, whatever you want to call it, it's still fear. And the reason why the Montana system exists, why the Great Montana Conspiracy exists, is because people live in fear and they're too afraid to stand up to the government. And they just say, well, that's the way it is. That's the way government is. That's the way it's always been. That's the way it's always going to be. They accept it. They've been drudged down to the point they're afraid to stand up and say anything. Like I said, it's just like asking the foxes to oversee the hen house. It's not going to change. It's not going to happen. The foxes are not going to sit there and say, oh yeah, we need to actually keep the other foxes from doing stuff badly, because, you know, foxes are foxes and foxes want to eat chickens. There's a lot of other things that want to eat chickens, but that's the basic gist of it. So the idea here is that, like the Commission on Practice, all complaints filed with the Montana Judicial Standards Commission are confidential. They're not reviewable by the public. You can't even check to see if a complaint has been filed against the judge. Complainants take oaths. When you sign the form, you take an oath under penalty of perjury to not speak of the complaint. Do not speak of the subject of it, or even that you have filed it. It permits an absolute control over where the judges are even reviewed. As I said, I personally have filed 5 complaints against judicial officers. Not a single one has ever received a response back from the Montana Judicial Standards Commission. Not a single one. And of course, the judicial officers were never removed. So obviously nothing was ever done. So, according to Montana Citizens Council on Judicial Accountability, the MTCCJA, they're the authority. They've cited that 98% of citizen complaints are dismissed. And I believe that. I absolutely believe that, because I never hear. I can't find a single article online as I was researching this podcast tonight. I couldn't find a single article where actually the Montana Judicial Standards Commission actually did anything to penalize a judge. I can't find a single example where a judge was removed. I couldn't find a single example where they've been fined or penalized. In years past, I have heard of them. I have heard random stories pop up. I was searching this year, and this year and last year, 2022 and 2021. I was looking for anything recent. I know I've heard of some in the past. I could not locate anything in the last year and a half, or a year and a couple of months. So, not finding any recent news, so obviously it's not very common. So I believe them when they say it's 98%. It fits right in there with what I've seen and heard. But because the complainants cannot even publicly report that their complaints were filed, they certainly can't declare publicly that they were ignored. Because guess what? If you declare that you filed a complaint and against whom you filed that complaint, you're in contempt and you can actually face jail time. You can be prosecuted for saying, hey, wait a minute, I made a judicial standards complaint against Judge Joe Blow. Once again, there is no Joe Blow in the state of Montana, not a real judge. And if the Judicial Standards Commission feels inclined, they can file contempt charges against you, and you can go to jail and or pay fines for speaking the truth, for saying you made a complaint and what the complaint was about. Now, Why is this bad? I mean, big deal. Judges don't have their stuff reviewed by public. Why is it bad? Well, let me give you an example. And this is a story I did find when I was looking around tonight. There's a New York judge, former New York judge, by the name of Michael F. McGuire. He was the county judge of the Catskill region of New York. He was elected in 2011. He committed egregious atrocities, just horrific acts of just deplorable conduct, without any warning from the complaints filed against him. He stood in office from 2011 to 2018. Now remember, like in Montana, New York's report process is confidential. Public is not allowed to disclose they've made complaints, who they made complaints against, nor are the records publicly accessible. So you have no idea of knowing if a complaint is made, much less how many, how frequently, who's been complaining, what complaints are about, anything. From 2011 to 2018, for 7 years, this judge sat with over a $200,000 annual salary with no repercussions for his misconduct. And there's no way of knowing how many complaints were made. But in 2018, the New York State Commission on Judicial Conduct finally made a complaint against him. It literally took 7 years to get around to it. 7 years getting around to these complaints. The judge was berating court staff, yelling at them, calling them names. He was making undignified comments in court, accusing defendants and plaintiffs alike of being willing to date drug dealers or or his words, sluts. I ask you to forgive the language, but that was his wording, his language. He would actually say, "What, you would actually date a slut?" I mean, he just say this thing to people in his courtroom. He was presiding over cases where conflict of interest and impartiality were questionable. He was actually representing friends and family members in personal cases. There was one case that was cited where a man said, "Hey, look, you're related to the son of the other party in this case." Didn't care. Continued to preside, and of course, guess who he sided against? He sided against the guy who wasn't his family member. The New York Commission on Judicial Conduct actually said that the judge lacked any form of candor during their investigation. And of course, we don't know how long that investigation lasted. We didn't even know, by the way, that this complaint was made because it was confidentially filed. The state appeals court did actually remove him in 2020. But the public was only informed about this, about the existence of any complaints, in March of 2020, when the court ruled that the judge had been notified of the commission's recommendation to remove him. So for 9 years, this judge was allowed to continue his atrocities of office, continue his abuse, continue his derogatory slander of people in his courtroom, atrocious behavior towards his court staff, clearly not following any kind of jurisprudence. His discrepancies were across the board, and yet for 9 years he sat without any penalty. And for that 1.5 years between the time that the commission filed the report and was actually made public, he still presided, did the exact same conduct with no restrictions, no penalty, no suspension, no nothing. He continued the same behavior, the same conduct, all the way up to the last day he served. And guess what? He didn't actually get fired. He resigned. He resigned before the court's action could be, before the court could actually make its order official. He resigned and simply took another government job. He took the Sullivan County's head attorney job. He just basically transitioned from one government job to another. There was no real penalty there. He just stepped aside and took another government job. And he's in that job to this day. No consequences. Where's the consequences? He's not barred from political service. He's not barred from other jobs. He's not given any kind of penalty or sanction or jail time or anything. He's just, okay, you can't serve. Okay, we're going to remove you. That's okay. I don't need to be removed. I'm already got another job. And this is the problem, because literally for 9 years, the public didn't know he was being complained against. Why? Because all the complaints were made from 2011 through 2018 when the commission actually started its investigation. Or actually didn't start its investigation, actually filed a complaint against the judicial officer in court. And even the filing was confidential, the initial filing. In 2018, we don't know how many complaints were filed because they're all confidential. We don't know the number of complaints. We don't know who complained. We don't know what was complained about specifically. We only know what the summary of the complaint was, because once it was known that he did this, once it was made public in March of 2020, then the record of the complaint was made public. Only then. 9 years. Now, if this had happened in states like New Jersey or Pennsylvania or Vermont, the filings of ethics charges are public. They know immediately. You can publicly, from the day the complaint is made, it goes and becomes public. Anybody can access the records information. If you're up before a judge, you can look at his record online to determine if he has had any ethical complaints brought against him, and you're aware and made aware implicitly what to watch for when you're in front of that judge. And you can add to it if he does the same thing to you. And most laymen, as I keep saying, don't know when the judge is doing something wrong. They don't know. And of course, the judges don't tell people where even to go to find out or to make complaints against them. Again, New York, like Montana, keeps things confidential. But seriously, who is being protected here? Who is being protected when the government keeps this a secret? When the government says, hey, we don't have to tell you that the judge is being investigated, what they're being investigated for, that they might have done something inappropriate or even criminal. We don't have to tell you. Who's being protected there? Certainly not the people. This is supposed to be a country of the people and for the people and by the people. Everything about the people. The people are not being protected when abuse in government is not made public. When the government actually hides the identity of wrongdoers, hides the identity and the wrongdoing of these officials. I remember, and I made a big deal about this in previous podcasts. The pre-trial publicity of anyone accused of a crime who's not a judicial officer is open to the public. The newspapers can run rampant with it and do whatever. They publish the names, the age, where they work, who their family members are, everything about them. The newspapers cover it. The television stations cover it. All the media covers it. Social media just runs rampant with it. No laws forbidding it. But you name a judicial officer, 9 years. 9 years for the New York judge to actually be finally held accountable. For the general public to even be aware that there were issues. If you go out and you steal a car and you get arrested, the general public knows day one that you've been accused of this crime and you're facing penalties and consequences. They know if you're in jail. They know what your bail is. They know possibly even where you work. Whatever the newspaper feels like telling the general public, they already know. Judicial officers can commit crimes in office and no ability for the public to know. That's a problem. It's a huge problem. It's a double standard, it doesn't apply. Remember, once again, my analogy. If the government fears the people, there's liberty. If the people fear the government, there's tyranny. The government doesn't fear the people because they literally hide any wrongdoing from the people. They have nothing to worry about or be concerned about because the people don't even know these judges are committing crimes or ethical issues. They don't know because it's not public. The people cannot make a judgment to hold the government accountable if they don't even know something's been done wrong. So how can the government possibly fear the people in this scenario? The government is supposed to protect the people, not people protect the government. Government is not protecting people by keeping ethics complaints confidential. Only protecting the government official who may likely be acting in a criminal capacity. And if citizens can have all their personal information blasted out for everybody for the slightest commission of a crime, why can't a government official? Why can't a judicial officer whose job is actually to oversee this kind of stuff? Wouldn't you want to know if your judge has a record of possibly dealing in drugs, possibly giving, his friends and family members preferential treatment? Wouldn't you want to know if he rules in certain ways against men and not against women? Wouldn't this all stuff be kind of important to know when you're in front of the judge? Wouldn't you want to be able to hold that judge accountable if he steps out of line? Wouldn't you want to know he's already done that before? He's been called on it before? Regardless of whether the complaint is founded in accuracy or not, the fact is complaints are made, and that oftentimes where there is smoke, there is fire. When there is a lot of complaints about the same conduct, the chances are there's something going on there. Maybe one complaint by itself might be just a disgruntled defendant, but you have 50 complaints that all say the same thing. Start to set a pattern. The old analogy: one thing happening, that's a happenstance. Two things happening is a coincidence. Three things is a pattern. If you have 3 complaints that say the same thing, you have 10 complaints, 50 complaints, it sets a pattern. You have a right to know, as a citizen, as a member of the people part of our country, you have the right to hold government accountable, and you can't hold them accountable if you're not made aware of the problem. These kind of things, rather than seek public comment on abuse, government oversight confidentially shelters the officials who are being complained about. I mean, if you go in front of a board of commissioners at a county level, as an example, or at a congressional level, and a law is suggested, you have the opportunity to speak to the lawmakers. You have, a lot of times things are opened up for public comment, so you have a chance to make a public commentary on what you think the law is, how it relates. If a rule is suggested, it's oftentimes made up for public comment. So why would the misconduct of judges, or even attorneys for that matter, not be subject to the same? Why, if a judge is accused of sexually assaulting someone, let's say he goes out in the courtroom and slaps a woman's ass, pardon my language. Say he goes out in the hallway and slaps her butt, okay? If this judge is accused of this, wouldn't other women have the right to be able to step forward and say, yeah, you did the exact same thing to me? Yeah, I think this is deplorable. He's done it to me, he's done it to me, he's done it to me. If you have a judge that sits here and says, I think you're looking pretty darn cute today, Miss Wallace. I don't think you need to be held accountable for this. Mr. Jackson, I think you are deplorable for taking the time here and wasting this pretty young lady's time. I'm going to dismiss this charge, and I'm going to fine you in contempt for $1,000 for even trying to bring this poor little girl up here and harass her like this. As a man, wouldn't you want to know he's like that with more than one woman? Wouldn't it be open to public comment of other men coming forward and say, yeah, you did the exact same thing with my wife, my girlfriend, my landlord, whatever else. He sees a girl, he's all kinds of complimentary and all flowery to her and decides in her favor every single time. Wouldn't that be something to know? I would think you'd want to know. And again, most laymen in court don't realize and don't recognize when a judge breaks a rule or a law. They don't realize when they act out ethical disparity. They don't recognize when a law is broken because they don't understand the law. They're not trained in law. They don't understand it. And there's no manual, quick reference manual. Oh, the judge did this. Oh, there's nothing like that. Nothing exists like that. Most people don't even know what the canons of judicial ethics are. If I say canons of judicial ethics, most people, I am sure, are thinking of cannons sitting in the backyard. If somebody says, that judge is a hard ass, and again, pardon the language, it's a layman justification for a judge just being really harsh, and maybe that harshness isn't legal nor ethical, and it actually is a violation of his standards and his oath of office. But how do you know that? How do you know if he is acting out, or if it's an issue to be concerned about, if you don't have some other community background or information on how this judge has acted as a general rule? When complaints are hidden, without even their existence being known, it empowers the abuse because it allows it to continue. Look at the example of the New York judge who continued for 9 years. It makes people feel like they're alone. If you don't think you have people saying the same thing, I mean, the idea is the more people make complaints, the more likely you're, the squeaky wheel gets the grease, right? But if you think you're the only person speaking up, you don't want to get singled out. Well, if I go up and I say this about the judge, he's going to know it was me. What if he's doing it to 50 other people, 500 other people, 5,000 other people? Wouldn't you like to know that so before you make a complaint? You know, he's done this exact same thing before. It's this exact same conduct that's been complained about before. You'd want to know that, because then you'd actually be more inclined to actually stand up and say something, because he's going to get your information. He's going to get it, and which means he gets to review your complaint, he gets to review your name, and if you're going back in front of him, oh, Jim Dandy, you're in trouble. Because this officer, you can't even openly declare in court that you made a complaint against him, and when he starts being even more biased against you, even more prejudiced against you, you can't say, Your Honor, you're being prejudiced because I filed a complaint against you with the Judicial Standards Commission. Boom, you're now in contempt of the Judicial Standards Commission's standards, and you can go to jail and be charged with a crime for that. And the judge doesn't even have to acknowledge it. In fact, he's technically forbidden from discussing it, just like you are, and therefore he can't. I mean, he could actually. He could waive his rights and his confidentiality, but who's going to do that? Really, seriously, who's going to do that? He'd have to acknowledge a conflict of interest and remove himself. But if he wants to sit over here and beat you down for daring to step up to him, he's certainly not going to do that, is he? Speaking again on the Montana, on the MTCCJA, their group, who was the, I always forget, it's such a long title, unfortunately, but it's the Montana Citizens Council on Judicial Accountability. But going back to them again, they have filed a petition, and I think it's a rather good petition, myself, and I will provide a link in the description of this video. And once again, if for some reason you're watching this video and it's not attached to the description, feel free to visit us either on YouTube or on monspiracy.podbean.com to see the text and the link. But in their petition, they call for a few things. They want removal of all judiciary appointed members. Remember, 3 out of the 5 members on the Judicial Standards Commission are appointed and cleared by the Supreme Court. The district court judges elect 2 of their own to sit on the board. It has to be ratified by the Chief Justice. The attorney who sits on the board has to be appointed by the Supreme Court. So 60% of the board is appointed by the Supreme Court, directly or indirectly. The reason for asking for this in the petition is they interpret the state constitution to provide for the legislature to, quote, provide for appointments of these individuals. The state constitution does in fact have this language. And the legislature gives 60% of power back to the judiciary. It gives 60% of the power to appoint in this back to the judiciary. Sadly, this is a gray area. This isn't an area that's as absolute as the MTCCJA would like it to be. I would definitely wish it were less gray, because that's a huge problem in Montana law. Oftentimes things are said so vaguely that it's open to interpretation, and this is an area where it's open to interpretation. They're not wrong that one branch of government cannot usurp power of another branch. Okay? But the legislature is tasked with laws affecting all branches. So it's within their purview to appoint or to give the appointment power back to the Supreme Court. The fact that the Constitution says that the legislature shall provide for appointments does not in and of itself say the Montana legislature shall appoint. It says it shall provide for the appointments. In other words, it will set the rules and the standards by which to do so. Giving 60% of that power back to the judiciary, therefore, is not technically outside the purview of their power as a legislature, because they make laws appointing the duties and responsibilities of all branches of government, both the legislative, the executive, and the judiciary. So if they're making laws for the judiciary and suddenly this somehow is omitted from that power, it needs to be clearer in intent, and the language provided doesn't create that clarity. The legislature can legally assign tasks to the Montana Supreme Court. The language only requires the legislature to provide for appointments. It does not say the legislature shall appoint. What the MTCCJA wants to do is say this language requires the legislature to actually be the one to appoint. And it doesn't say that, not clearly. I can certainly see that viewpoint. I can see where they want the word provide to be the word shall. And unfortunately, provide for doesn't necessarily equal. It can, it could, if you wanted to read that way and to interpret it that way, it could mean that. But because it's a gray area, and they're specifically challenging whether the legislature has the ability to assign powers to the Montana Supreme Court, it's unfortunately an area that's gray. If you wanted this power to say this, it needed to be clearer, and as I've mentioned, clarity is not a strong point in Montana law, which leaves things open to interpretation. And guess who interprets law? The Montana Supreme Court. So if the Montana Supreme Court is not going to take 60% power away, and I'll deal with, and I'm not just saying that hypothetically, they actually did it this last year. They actually aggressively went against trying to lose power with this just this last year. I'm going to get into that in just a minute. But the language in this particular instance, it doesn't give the clarity that the MTCCJA really wants. It does not give them the clarity and the definition that says this is a mandate for the legislature to assign. If one assumes that provide for means that they shall make, then yes. If it says the legislature shall make these appointments, then absolutely, it's a mandatory obligation. If it says it shall provide for, they just have to make arrangements, and they have the power to delegate powers to the other branches. The language is open to interpretation because it does not specifically answer the question of what the purpose of provide for means. There's no secondary definition that says provide for shall mean this. Provide for is very open, very vague, and without specific limitations or structures. And again, this is a problem with far too many Montana laws. They're so gray, it just becomes open to interpretations, and the courts are the ones who get to interpret the laws. Without more specificity, this argument doesn't get much traction, in my humble opinion. It's not necessarily a wrong interpretation. I'm not saying it is wrong, because it's not. But it's not a strong argument when you're basically asking whether or not this language means one thing or the other. The legislature is clearly interpreted to mean they have the power to set it aside. They give it over to the Montana Supreme Court, and the Montana Supreme Court, who has the power to interpret and declare laws unconstitutional or whether they are actually valid, is not going to say, no, we don't have that power, because they really want that power. The second thing they ask for in this petition is they propose an amendment to the Constitution, which I think is a much more viable answer. It calls for a 12-person panel, 10 citizens, 1 retired judge, and 1 attorney. It's similar in number to other state models, though it's in different structure than any other state model. But it calls for essentially 10 out of the 12 members of this committee be citizens who have no legal association. They're not attorneys, they're not judges, nor are they former judges. They cannot preside on this panel if they have any legal background. 10 people out of the 12. Vastly outnumbers the previous model where the judiciary literally controls the whole board by majority. It takes a vast number of normal, everyday citizens to overlook this situation and circumstance and say there's maybe something wrong here, and we have no reason to side with the judges. We have the ability to look at it and say there's something wrong here. The foxes are no longer in control of the hen house. Big surprise, the Montana Supreme Court has a problem with this idea. This, I believe, is the part of the petition has the best chance of success. Republicans in the legislature already tried to reform the JSC just this last year. And this is a quote I really like from this petition, and I think it sums it up so well, sums up my argument so well. When a judge purposely usurps or breaks the law, or violates judicial canon of ethics, they need to be dealt with harshly, just as our courts deal harshly with citizens who violate the law. Hello. Doesn't that say what I've been saying all along? That that government officials have blanket immunity, they don't suffer the same consequences as a normal citizen. A normal citizen breaks the law, they get publicized all over the place. They get treated harshly, they get penalties, they go to prison, they go to jail, they lose their jobs. They have massive financial costs and burdens to inherit. Judges, especially when everything's confidential and you can't even verify if a complaint has even been made, and the person making the complaint is forbidden by the law to actually admit or acknowledge they made a complaint, there's no way to know if a judge is being held accountable or not. And in 98% of the cases, according to MTCCJA, they're not. And I believe those statistics. I have signed the petition, and I endorse it. This is my official endorsement of an online petition. I endorse it, and I highly recommend anyone watching this take the time to read it and sign it themselves. Again, I will provide a link in the text attached to this video, and once again, monspiracy.podbean.com is where this video originates. The text will be definitely attached there, and it should be attached anywhere else this video is posted online. But if not, visit us on YouTube or visit us on Podbean to get the actual link. Just to give you an example of how some other states do this, as an example. And every other state I look at, almost every single one has the judiciary as a minority. The judicial and legal profession is a minority on the council. But specifically, I took some time and researched one model, just a state in general, New Mexico. 7 civilians, 6 legal professionals, 13-member commission on practice. Civilians are appointed by the governor and are specifically prohibited from being legal professionals. They cannot be former legal professionals, they cannot be existing legal professionals, they can have no legal background. 2 lawyers, which are appointed by the state bar, which, keep in mind, in Montana, the state bar is an integrated part of government. In the 1970s, the Montana redid its constitution, and Montana gave the power to the Montana Supreme Court to order and form an integrated branch of government for the Bar Association. So now the Bar Association is actually answerable and underneath the Montana Supreme Court. Just as the Montana Judicial Standards Commission is, just like the Commission on Practice is, all aspects of law in the state of Montana have been absorbed underneath the Montana Supreme Court, which makes them overseeing all aspects of law. It is a huge monopoly, huge monopoly. But in New Mexico, it's independent. It's actually an independent agency. It also calls for 4 judges, and it breaks it down really interestingly. It's 2 Supreme or Appellate Court justices, 1 municipal court judge, and 1 magistrate court judge. And magistrates are basically the equivalent of justice courts here in Montana. They're essentially lower level county courts. They aren't state courts, they're county courts. But because of the independent government agency, the New Mexico model is, it's technically part of the judiciary, but it's not answerable to it. And in Montana, the Judicial Standards Commission is absolutely answerable to the Montana Supreme Court. Absolutely. Not only is it part of the Montana Supreme Court, it's answerable to it, and the Montana Supreme Court appoints 3 of its members, or controls the appointment of 3 of its members. 5 members. In all fairness, as I mentioned, Republicans in the Montana legislature try to reform Judicial Standards Commission just this last session. And for anyone who's not aware, Montana is served by a citizen legislature that normally serves once every 2 years for 3 months. It meets an odd number of years, so 2021, 2023, 2025. They can call a special session if some kind of an emergency comes up or something must be dealt with urgently, and they can meet in even numbered years. But in the odd number of years is when they meet. So we just had a session at the first 3 months of the year back in 2021, last year. In that session, there was a House bill called House Bill 685, which would have reformed the Judicial Standards Commission to be a larger citizen panel with greater power to remove judges. It would have taken the power completely away from the Supreme Court. Big surprise, it was lobbied against by the Montana Judges Association and the Bar Association, which of course, as I mentioned, is part of the Montana Supreme Court. Chief Justice Mike McGrath and other judicial officials were caught with their hands in the cookie jar this last year, lobbying against legislation the Montana Republicans were trying to bring into fruition. I've mentioned one previously, and I'll rehash that in a minute. But in this particular case, Chief Justice Mike McGrath's, one of his emails was actually discovered by the legislature. The legislature obtained a copy of it and called in Mike McGrath for a meeting to basically ask him what was going on, give him some information about this as they try to investigate what's going on. The House Bill 685 was shot down because of the massive lobbying that the Montana Supreme Court, the State Bar, and the Montana Judges Association mounted against it. Mike McGrath, in his email, actually said that he believed giving citizen oversight would be the equivalent to killing democracy. I mean, just the idea and the audacity of that statement. Giving citizens oversight of government would kill democracy. Ladies and gentlemen, democracy is supposed to be about the people electing officials by the people, for the people, all that kind of language kind of requires the citizens having some capacity of oversight, doesn't it? Mike McGrath actually believes, genuinely believes, put it in his own words, in his own email, that giving oversight to normal people, beyond, of course, the power to elect him in office, okay, beyond this power, would kill democracy. He actually said that.